My name is Paul Stewart. I'm the Assistant Deputy Mayor in Mayor Lightfoot's office. I've also served as the Cannabis Coordinator for the City of Chicago for the past several months. So we are very appreciative of your interest in the industry, and we hope that the information that we provided today has been helpful and useful, and we're here to answer any questions that you have today. I'd like to introduce the panel that will be here with me today. Steve Valenziano, to my immediate left, is the Assistant Zoning Administrator for the City of Chicago, Department of Planning and Development. And Katrina McGuire is an attorney at Thompson Coburn, and she is a zoning attorney that is working closely with us in helping to develop the policy, but also working in the cannabis industry as well. So again, we appreciate you all being here today. I'm sorry. Sure, I'm sorry. I have a very light voice. I'm sorry. Is this better? All right. So I'm going to go through a small presentation initially, and then we'll have some discussion here amongst the panelists, and then we'll open it up for a question and answer. So I just want to give a little background. I'm certain that most of you all are aware of how we've come to this moment in time here in the state of Illinois. But the state of Illinois has the licensing authority under the State Cannabis Tax and Regulation Act. We started with the medical program over 5 years ago, which was initially a pilot program, which is now a permanent program. And the legislature in Springfield passed a state act to create the legalized adult use cannabis industry here in the state of Illinois. What the city has the ability to do is determine the time, manner, place, and number of cannabis businesses that can locate within the city of Chicago. The licensing that was done by the state was done by Bureau of Labor Statistics area, so it's like a region. And so the Chicago region is not just the city of Chicago, it extends all the way to Naperville and Elgin. And so the number of licenses, when you hear the number of licenses that have been authorized for Chicago, they're talking about the region, so it's also the suburban areas as well. Obviously, with the population and the tourism that we have here in the city of Chicago, a number of the businesses have decided that they want to locate here. And so we'll talk about the regulatory process if any business wants to locate in the city of Chicago. So the Zoning Board of Appeals is part of the zoning process here in the city of Chicago. Anytime there is a special use of which adult use cannabis and medical cannabis sales are considered a special use in the city of Chicago from a zoning perspective, the applicant, the individual who would like to open that business needs to come before the Zoning Board of Appeals and present their plan for that business establishment in a location where they'd like to site. And there's a hearing before the 5-member panel. That panel considers and approves or denies the applications for the special use, which is a variation from the regular zoning requirements in a particular area of the city. The ZBA does make the final decision, and those decisions do have the ability to be appealed, but once that appeal process is over, that decision is final. If the ZBA decides that they will not approve your application at that location, you can place another application in for a different location. So it's not as though if they deny your application for the special use that they're denying your ability to operate. It's just at that particular location, due to some environmental impacts or community impacts, they thought that it wouldn't be a proper venue for a cannabis-related business. Sorry, I'm not the technical guy. So again, the city of Chicago, because we have the ability to determine the zoning regulations for the cannabis businesses, we looked at the initial map of locations where the medical cannabis dispensaries cited themselves in the city. And most of you all may know that most of the existing medical dispensaries are located on the north end of the city. And so we wanted to make certain that as the new licenses and the additional sites came into the city, that they were spread evenly throughout the city of Chicago. So we created a system of districts and caps, and we created 7 cannabis districts throughout the city, and they're divided pretty much so that there's an even amount of population or residents in each of those districts. And then we also applied a cap of 7 dispensaries at this time in each of those 7 locations. Now, we will reevaluate as additional licenses come online for dispensaries later in the year. We'll make a determination based on the existing locations, the +1 sites that the current medical dispensaries have the ability to establish, and then the additional licenses that are awarded by the state in May. The city does have the ability to raise the cap from the current 7 in each district to a maximum of 14. So there are a number of different factors that we'll take into consideration to make the determination how many additional dispensaries we allow in each district. But there will be some movement, and we'll make certain that everyone's aware of that once we have the ability to do the evaluation in the first several months. We've also determined that due to the unique properties of our central business district and the tourism and commercial activity that happens in the central business district, as well as some sensitive security measures, that we have established an exclusion zone in the central business district. It's not the entire downtown of Chicago, but it's a specific area that's bounded by North Avenue on the north end, Van Buren Street on the south border, Lake Michigan obviously is the easternmost boundary, and State Street in River North, which is anything north of the river or Wacker Drive. And then if you're south of the river, it goes over to the south branch of the Chicago River, which is basically Wacker Drive down where Willis Tower is, almost said Sears Tower. So that is the exclusion zone, and we will not allow any cannabis-related business in that area. It is within the central district on the previous map, so there will be locations near and in downtown, but just not in this particular exclusion zone. So sensitive uses, the state has put some restrictions and prohibitions on how close cannabis dispensaries can be to one another. So there is a 1,500-foot distancing requirement between cannabis dispensaries. But we also wanted to protect our vulnerable populations here in the city of Chicago. And so we've also established a 500-foot distancing requirement from any school. And school is a legal term. So we're talking about kindergarten through 12th grade only, and that's private or public schools. So if you're looking to cite any cannabis-related business, it would have to be outside of that 500-foot distancing from a school. You will be required, if you go through the special use process, to have a determination, and Steve can speak more to what is an acceptable form of documentation to show that you're no closer than 500 feet away from a school, but the department will also verify that as well. We're going to take all the questions right at the end. I'm sorry. As I indicated previously, all cannabis-related businesses in the city of Chicago are required to go through our special use process. And there are several requirements that we've established to make certain that the communities in which cannabis businesses are located do have an ability to speak to and hear from those cannabis businesses before they're allowed to open. One of the requirements that we thought was very important from a community engagement perspective was that any applicant does have to have a community meeting in that community where they're looking to cite their business. They have to make public notice 2 weeks in advance of the meeting by notifying the local alderman, placing an ad in the local newspaper, as well as sending a mailing out to any property owner within 200 feet of the location where they're looking to establish the business. So we thought that that was a way for the local community to understand that this new industry was establishing a location in their community and have the ability for the community to have a voice to ask questions and address any concerns that they may have. We also require all applicants to give us an economic disclosure statement, because we want to understand the ownership structure. There's been a lot of discussion about the lack of diversity in the industry, and so we want to make certain that we fully understand if there's a team or there are multiple equity partners in the entity. We want to make certain that we understand exactly who the owners are in that application before it's approved. And then finally, for the adult use dispensaries, the way that we ensure the even distribution throughout the city, you may have heard about the lottery that we held back in October. That is the lottery for license holders to choose which district they want to site their dispensary in. That was not a lottery to give out licenses. Again, the city of Chicago does not license any cannabis state licensed business. And so the lottery was a way for individuals that have licenses or organizations that have licenses to determine which of the 7 districts they wanted to site their location in. And so that was the purpose of the lottery. We do have, I think, 7 additional locations left in the city of Chicago today. And that's before we increase the number, the total cap that we've imposed. Once we determine how many we want to ultimately allow in the city, and once the additional licenses are awarded in May, we will have another lottery for those individuals to determine what district they'd like to site their cannabis dispensary. This graphic just shows the dispensary special use process here in the city of Chicago. It goes through the exact process that I just spoke to. In the first round of special use for dispensaries, there's not a requirement to have your exact location. You only have to show the state, that the city of Chicago is allowing cannabis dispensaries, and that there were specific zoning regulations that you would have to abide by. When we get to the additional cannabis businesses, which will be the next slide, it goes into the process for craft growers, infusers that are currently seeking state licensure now, and that's a slightly different process. So the state does require that you have a location identified when you submit your application. And so you will have to come through the city of Chicago for our zoning process initially and file an application for a special use prior to being allowed to move forward with your state application. We'll put these slides back up at the end, and feel free to take photos of any of the slides as we move through the presentation. Okay, so that's the end of the presentation. I'm not the IT guy, I'm telling you. But we want to engage the panelists that are here. Again, Steve Valenziano is a veteran of the city of Chicago in the zoning area, and so we know there's a lot of, if you would, confusion around the process, and we wanted to make certain that we were here to answer any questions. And again, we have the benefit of having a zoning attorney here as well. So feel free to get this free advice. Ask very relevant questions so that you can get accurate information as you move forward in your process. So I just wanted to toss a couple of questions to Steve and Katrina just to get us started here, and they can answer in whichever order they choose. Steve, let's go with, what is the rough timeline for someone to get through our city zoning process?
It would be roughly from the time that you would get your opinion letter to get through the zoning board hearing. We're thinking it's 60 to 90 days now, because there is a requirement of our ordinance that you hold a community meeting also in the ward near the location of the proposed location of the dispensary or cannabis facility, to have a community meeting in that ward at least 2 weeks before your zoning board hearing. So that probably adds another month onto the typical 30 to 60 day delay or wait.
And then the next question is, how do you know which firms and lawyers will be able to successfully get you through zoning? That sounds like an appropriate one for Katrina.
Yeah.
Don't be biased.
No. Yeah, I know a couple good ones. I think that's, I'm not here to sit and make recommendations, and I know that's not what Paul's after. I would just reinforce that sort of the process and who you engage in it is incredibly important for the success of your application, right? So the zoning aspect is going to be a key component for you. Once you have the conditional license issued by the state, you get into a zone that you're successful at the lottery of getting a pick in a zone. So now you have to identify the property and move forward through the zoning Board of Appeals process. And you're going to need a couple consultants along the way. You will need a zoning attorney at the zoning board in order to get through this. The legal standards that are set forth in the city ordinance for meeting the special use or being granted a special use do take a fair amount of analysis, and you have to have a pretty robust application, findings of fact, and witnesses prepared for purposes of that hearing. The other aspect, and Steve can probably talk to it a little bit, is that there's this 500-foot radius to schools that's set forth in the city ordinance. And as we all started to work through our application process in this first round of special use applications, we all recognized that it was very hard, both on the city side as well as the applicant side, to determine exactly whether or not there are actually schools within 500 feet. The State Board of Education doesn't really have any mechanism for certifying or verifying whether or not you're in that. So we are having to do it as the applicants. And so you have to retain a land planner or some sort of real estate professional who can provide a map for you to show that you're outside that 500-foot radius, as well as assess that, essentially walk that 500-foot radius to determine and ensure, be able to certify that there are no schools there. So, you'll need a land planner or appraiser, in some cases both, and an attorney, certainly. I think it's worth probably researching. I think you can find there's a lot of the same consultants appear at the zoning board all the time, and it would behoove you to find somebody who has the experience in maneuvering through that process. It'll save you time and money in the end.
And just to add to that, typically for anybody coming to the Zoning Board of Appeals for any kind of project or proposal, and if somebody's not familiar with an attorney or the appraisers, what we recommend is that you come down. The Zoning Board of Appeals is held the third Friday of every month in City Council chambers in City Hall, and we encourage people to come down and to see how the procedure goes, and to also then, if you can ask for cards, business cards, and recommendations from attorneys, appraisers, people that are there representing other clients. It's the third Friday of each month. The Zoning Board of Appeals is held at City Hall, typically in City Council chambers.
What time?
9 a.m. till they're done. Sometimes that's 11 o'clock at night.
So the next one's February 21st, right?
Yes.
Yeah.
And does the radius between just dispensaries?
I mean, do you want?
No,
Yeah.
we can start.
Yes, it applies only to dispensaries. That being said, the ordinance allows for a craft grower to have a same site dispensary. If you choose to have a craft grower with a same site dispensary, it is considered to be a dispensary. You have to get a dispensary license from the state. You're going to have to get a second special use for that dispensary. And at that time, then, we're going to see if that craft grower, because it has the dispensary, is within 500 feet of a school. So anytime that there is an adult use dispensary involved, then the 500 feet from a school comes into play.
Let's go in the back first, because that young lady had her hand up first.
So if we're gonna start the public comment, the Q&A, we're gonna have folks line up instead of picking and choosing who's asking questions. So if folks can line up on this side or that side, we'll start.
Hi, so if I think I heard you correctly, you said that 500 feet was for grades K through 12. Or is there any regulation for daycares or preschools or churches?
There are no regulations for daycares or preschools. It's If it's a parochial school, a public school, charter school, all of those count. It's the K through 12 state mandated education. The city does have a list of the ones that we know of and that we recognize, and we check that against the survey that we ask the applicant to provide also.
Okay, thank you so much.
Hi, good afternoon, everyone. My name is Eric White. I'm a cannabis rights attorney, and my mission is to help individuals and businesses solve their cannabis law problems. You can visit my site at IllinoisCannabisRights.com. My question for the panel, you mentioned earlier that under the transport, the cannabis infuser, as well as the craft grow license, a special use permit is required from the city of Chicago. Is that correct? As opposed to the dispensary license where it wasn't required.
So there's not a special use requirement for the transporter's license. There is a special use required for the craft growing license.
And for the dispensaries, sir, the only ones that were not required to get a special use were the ones that had existing medical dispensary licenses in Chicago.
That's correct.
Yeah.
I'll be brief. That's correct. What I'm talking about more specifically is the fact that all three licenses require that the locality, the city that you're trying to operate in, have to give permission for zoning. And that's what we were talking about. You said right now, sir, I believe the timeline was 90 days. Is that what you said? How long it would take?
That's probably the average time from the time you would make your first request the opinion letter, which acts as your denial so that you can go to the zoning board and file for an application, to the time you would have your hearing would be probably 90 days.
And that's where the dilemma is, because these applications, sir, are doing 46 days. These applications for craft grower as well as transporter as well as...
So to answer that, the form that comes from the Department of Agriculture, that can be checked. There's three sign-offs on that form. One is that you comply with the zoning of the local municipality. The second is that you have made an application for zoning with the municipality. And the third is that the municipality does not allow it. So once you have made your application with the Zoning Board of Appeals, we will then, once you've filed that application, we will check off that second box that allows you to proceed with the state.
Thank you very much.
Question about when documentation needs to be provided.
No, it's okay. Let him start since he's already done. Okay.
Hello. My name is Mike. I just had, they asked both of my questions that I actually had. But can we go through the lottery process one more time? I'm just trying to grasp. So if we win the license, we want to apply in the city of Chicago. We want to put a dispensary there. Like, how can we just walk through that one more last time for the dispensary lottery?
Sure. So again, we established the question, well, everyone heard them. The question about how the lottery process works and the rationale behind it. We established 7 cannabis districts in the city, and we've applied a cap. So you can only at this point, you can only put 7 dispensaries in each of the 7 districts. So obviously there were more than 7 dispensary operators that were seeking a special use. So they all had to they were all pulled through the lottery process. As their dispensary organization was pulled, they were able to immediately say which of the 7 districts they wanted to go into. It's not the exact location in that district, but they would either choose, south or central or north of one of the 7 districts. And then each lottery draw had the ability to choose a district until either that district was full because 7 individuals had chosen that district, or until all of the balls were selected.
All right, thank you.
So 2 questions. One, in the process, when you apply with the opinion letter, do you need to provide the complete application and economic ownership statement at that time, or do you provide it when you apply with the Board of Appeals at the hearing?
You would need to have all of the materials that are included in the application, but for your findings of fact and your notice of the public hearing that is required. So we would want to have the EDSs, we would want to have all the other information complete, then you can complete that application as you go along towards your hearing, because you're not going to be assigned a hearing date until we get evidence that you've had, either you've noticed or you're having your public hearing that's required, the community hearing that's required by the ordinance.
But your question was about the opinion letter?
So to get the form checked to complete an application, do you have to have a complete application? Is the question to the state.
The answer is it's not a complete application, but it's a,
Everything but the that letter.
right. It's, you know, a very, it has to be kind of far along, is what I'm saying. You have to have the initial information. We understand there's going to be more information that you're going to have to gather. It's a very complicated application, so like the findings of facts and those things can come later. But you have to have those before you'll be scheduled a hearing date.
So I'm referring to the craft grow application with the state of Illinois. To be that application at the beginning of the process or at the end of the process?
What we need is that letter from the state of, well, we don't need that letter from the state of Illinois. What the city of Chicago wants is you to have an opinion letter saying that you can proceed. Then once you make that, that's what gets you to the Zoning Board of Appeals. Once you get that application from the zoning board and fill it out, file at least the initial parts of that application, that's when we will check off that form from the state, from the Illinois Department of Agriculture.
But you're asking, do we want your entire state application
No.
at the time that we apply, that you apply? That, no, not for a craft grower.
And then when we do provide that full application, will that application be made public as part of the zoning appeals process? Or will it remain confidential?
Your entire state application? It will not.
Thank you.
How you guys doing? My question is, it's kind of like a multi-part question. So for the craft grower license, how they allow for cultivation, it doesn't really specify about processing, and neither does the infuser license. My question is, for the craft grower license, will they allow for processing like crude oil and distillate and isolate and stuff like that for the cultivation? My second question is, in the infuser license, is it meant to produce non-smokable products only, like edibles, topicals, tinctures, and things like that, which ties into my first question? And my last question is, can the infuser and craft be located in the same building, or do they have to be separate build-outs?
Any of the license requirements, those are questions for the state. The city does not control those licenses or inspect those licenses. So whatever the state rules are for those licenses, that's what you have to follow. As far as from the city of Chicago, you could apply for a processor, an infuser, and a craft grower, all in the same facility. Each one would require a separate special use application that could all go to the zoning board at the same time and be heard at the same time, or however the applicant desires it, if they prefer to go with the craft first and then come back and get the others later. But each one would require a separate special use from the city. As far as the state regulations go, I would leave that to the state.
Where can I go to ask the state for the actual definition for it? Because it's kind of vague and ambiguous. It don't really tell you exactly what you could do as far as the cultivation license goes.
Sure. So the City of Chicago's website, cityofchicago.org /cannabis, that's our cannabis information page. If you go there, all of the state agencies, including the Department of Agriculture, their contact information is there. And we do have some initial explanations of the state application, but cityofchicago.org /cannabis.
Okay, I guess the last question is, will the submission of a zoning amendment and a special use license, would that suffice for the city council for application?
The application is with the Zoning Board of Appeals, and then once that is docketed and you have your hearing, it'll either be approved or denied, and then you would take that to the state, and the city council's not involved at all.
Okay, thank you.
Hello, my name is Mark. So I'm looking at a building right now, which is zoned for C1. It's a C1-1. Is it correct that it needs to be C2 and higher?
Yes.
Okay. So if I'm gonna maybe put in the request to rezone that property to be a C2, what do you suggest be the process of me doing the opinion letter? Do I want to do the opinion letter first at C1, or do I want to go through the zoning amendment first, then request the opinion letter?
You'll want to go through the amendment first, because what we're going to do is check the zoning that is in place, the designation that's in place on that property. And if it's not proper, then we're going to say that you could not move forward.
Shut it down.
Yeah.
So how long is the zone, how normally the zone amendment process take?
An amendment process, it typically takes 60 days to file an application with the Department of Planning and Development that then gets introduced to City Council through the City Clerk's office, and then goes to a committee hearing, and then finally gets voted out by full City Council.
And for the zoning amendment, you should start with your alderman. Go talk to your alderman's office about rezoning.
And what type of information would I be expecting from him, from the alderman, in regards to this?
I think you would just reach out to the alderman's office to let them know that you're interested in rezoning the property for the purpose of ultimately seeking a special use for a cannabis business establishment there. But it would be my strong recommendation that you start with the alderman's office in the case of a rezoning.
Thank you.
Before we get to the next question, can we ask folks to do one question at a time, just because we have a line and limited time? We're happy to connect with you guys after for additional questions.
So for the craft grower and the infuser, you have to have a site already established, but do they also go into the lottery?
No, the lottery was just for the dispensaries.
Okay, and then can it be a mixed-use building? Like I know for a dispensary you have a mixed use, but can you, for a craft grower, infuser, can it also be a mixed-use commercial building?
Yeah.
Is the answer no from the state?
No, I think you
They-
can.
yeah, they don't
Oh,
have a requirement.
from the city's regulation, it could be a mixed-use building. I don't know what it is for the state, if they have other requirements, maybe, I don't know. But from the city standpoint, it can be a mixed-use building.
But you should note that for craft grows, right, it's limited zoning districts that the craft grows can be established in. It's in the M districts and PMDs.
No,
No, they
no,
can
I'm
go
sorry,
in-
the
Can we do
craft growers,
C2s?
the craft growers you can do C2s,
Apologies.
the DCDX, and the
Okay.
manufacturing
Sorry about
districts,
that.
yeah.
Okay, thank you.
It can go to the C2, C3, DC, DX, PMD, and M2 and M3. So the heavier manufacturing districts and the more permissive commercial and downtown districts.
Hi. Right now, I'm a real estate professional, and I've been through the zoning process before in the city of Chicago. And it can be a very long, arduous process, and it's also you need a lot of financial resources. So for people specifically going into dispensaries who do not have to have their location yet, and maybe their funding is dependent on getting the license, what can they do in this kind of, in the meantime, and they don't have the license yet, to kind of get in front of the process? Because although ideally it could take 60 to 90 days, it could also take up to 6 months to a year, or not a year maybe, but 6 months, and you only have 180 days to get all of the stuff together to have your conditional license. So I'm just kind of wondering, do you guys have any suggestions for people who are trying to get in front of this process, but might not have the resources yet until after their license is given?
I would recommend that you start to identify locations, right, that might be desirable, that might be available to you, and do some of that initial legwork to determine that, A, it's zoned correctly, right, so that you wouldn't have to perhaps rezone it first, number one. Try to identify if you're within outside the 500-foot school radius, and do that sort of legwork so that you're not starting at ground zero there.
I would also add that due to the lottery process and not knowing what district you would ultimately end up in, when you do that due diligence, you should make certain that you're identifying a location in each of the districts, so that when you go through our lottery process, you already have an identified location. And so whichever district, whatever district is available, you would know which district you want to choose from.
So your suggestion wouldn't be like to necessarily try to have a community meeting prior to, or any of that nature. But isn't there a lot of people, I've heard that March, there's a huge a lot of cannabis companies are coming in March to try to get special use permits. Is that for only existing, or are these bigger companies who are getting ahead of the game, who have the resources to go through that process already before licensure?
Yeah, that's not a resource issue. That's the existing medical operators who are establishing their next site. They've already been allowed to do that by the state, so they're moving through their zoning process now.
And just one other thing, for those opinion letters, you have to have consent, either be the property owner or have consent of the property owner to request an opinion letter, because it's acting as your official denial to get to the zoning board. So you don't, we've had some people come in and just have a bunch of addresses and wanted opinion letters for each one of those, and that would be a waste of their time and money because they don't have that consent. I don't know, just so you know, you have to have consent.
Thank you.
Good afternoon. My question is about other cannabis business establishments, but not one of the ones listed up there. Does the city of Chicago have any plans to allow for spaces for consumption, like similar to a hookah bar? And would they follow the special use process, or is that more of like a licensing question from the state? Because I know the state is not allowing licensing for those types of establishment at the time, but I was wondering if the city of Chicago has any plans to allow for spaces for public consumption.
Sure. So the question for those who may not have been able to hear is whether the city of Chicago will allow for consumption licensing in the city. So in the fall, the state did determine that consumption for now will only be allowed in state licensed dispensaries or retail tobacco shops, such as a hookah lounge or a cigar bar. The city of Chicago is prepared to move forward and establish consumption licensing in the city, but there's also an effort to have the state expand on their current exemptions or where they will allow consumption. So instead of putting our consumption ordinance in place now, we're going to allow the state to give us a little more direction over the next several weeks and months, and we will eventually have a consumption license, which individuals will be able to come in and apply to the city of Chicago.
Thank you.
Hello, good afternoon. My name is Estela, and my question is, what are the building requirements to be able to grow the wonderful plants?
So the state of Illinois is the licensing authority for craft growers, which is in cultivation centers. And so all of those requirements come through the Illinois Department of Agriculture. And so you can access their website through the city's website or go directly to the state of Illinois. But it's the Illinois Department of Agriculture, and it'll lay out all the requirements in the application.
About zoning, I have located a building, and the zoning is C1-2. Will that qualify, or I have to whoever zoning?
No, the C1 district does not allow, it prohibits the use. So you would need to go to a C2 or a C3 district.
Oh, thank you.
Hello, my question is about the 500 foot radius. The state law allows 1,000 feet, so I'm wondering, does the city's law supersede the state law? And does it also apply to public libraries and parks as the state law does?
There is no state requirement for distancing from schools. That is the city of Chicago's requirement. And it is only for schools as defined in the zoning ordinance. So again, K through 12, that are offering state mandated education.
Ma'am, what you're probably thinking of, and there's been a lot of confusion around it, is that the state statute provides 1,000-foot radius from lots of sensitive uses, including libraries, parks, et cetera, for the advertisement of cannabis.
Okay.
Not for the establishment
Not
of
for the
those
dispensary.
businesses.
Okay, thank
Right.
you.
Good evening. My question is, what would be the appropriate zone for a transportation license application?
the transportation or the transporters, since they cannot have any product on site, they cannot warehouse it or store it. We are treating them, depending on the scale of the project, either as a typical transportation, warehousing. It's not warehousing, but under that category, so a typical cartage firm, or we would also look, if they were smaller in size, as a business support service. So they would be allowed, the smaller size ones would be allowed in all the business districts, B1 through B3, all of the commercial districts, and the downtown DX and DS districts. The larger ones, that may be something larger in scale, would be in the manufacturing and in the planned manufacturing districts.
Thank you.
Okay.
Hello, are businesses with a drive-through allowed for dispensaries?
No.
Okay, thank you.
Good idea.
Hello, thank you. First, a point of clarification. I think you've said that you cannot apply simultaneously for a zoning amendment and the SUP, is that correct?
You need to have the zoning in place before you can get your special use, yes.
Thank you. So my question revolves around the timeline process in calculating zoning and the necessary approvals if you're awarded a state license. In the city of Chicago, if you do get the SUP, is there a trailing process because of the regulated nature of the business for a business license to be allowed to fully operate within that facility that also needs to be planned for? And I don't know if you can answer that or not.
Your license is coming from the state. So, okay.
Is a restaurant operator or is, other small business operators in the city of Chicago, you have to have a business license also. Is there a requirement similar to that for this business?
Oh, no. There is the state preempts any city of Chicago license for these types of businesses.
Okay, great, thank you.
Hello. My question is, once we receive the approval for the dispensary license, does the zoning and the lottery apply if you're anticipating having a dispensary in the suburban area?
No, this is just strictly the city of Chicago's jurisdiction.
Mhm.
So anything, you'd have to go to each separate municipality to find out what their regulations are.
Okay, thank you.
So, in regards to the zoning amendment, I'm not sure there's many dependencies, to get approval for zoning amendment, but being that I'm at a C1 now, is there anything that makes my process a little bit faster, going from C1 to C2?
No, it's the same process going from any district to another. Yeah.
Yes, I just wanted to get clarification. So for the consumption of cannabis on site, right now it's only limited to established hookah bars and cigar lounges and things like that. And my question is that going to be a separate process for starting? If I was to start a hookah lounge now, would I be able to allow consumption on site now, or is that something I'm going to have to wait for consumption licenses later down the road?
You would have to wait. Currently, we do not, the city of Chicago does not allow for on-site consumption.
Okay.
We are working on the ordinances to allow that, but yeah, currently you could not.
Okay. Thank you.
Hi, how you guys doing? I have a question in reference to the transport you were talking to the gentleman about earlier. Now, you mentioned something about storage, that you can't have a storage facility. Now, I'm trying to understand what you were saying, because you do the transport, you have the trucks, whatever. Are you saying you storage the items in the truck, or is there a storage facility, or what are you saying exactly?
Well, again, that's the state regulates that license for transporters, and this, from my reading of the act, that the state will not allow for a transporter to have any product on site, cannot hold it, cannot store it, cannot warehouse it. So you would just be transporting from a craft grower or a cultivation center to a business to sell.
So the products would have to stay in the truck, is that what you're saying?
They could only be transported in the truck. You couldn't have a truck, park it on your site and keep the product in that. It has to be in the truck, put in the truck from the cultivation center, and then taken out of the truck and put into the dispensary.
It's not allowed, so it's only point to point. If you have a contract with a craft grower or a cultivation center and you're delivering to a dispensary, those are the only 2 points that truck can go to. You have to leave the grower and take it directly to a dispensary without any stops in between.
So is there a special license for storage? If you want to just say, well, like a U-Haul or a UPS, something like that?
Those don't exist right now.
All right, thank you.
Mhm.
So you mentioned, you talked a lot about dispensaries in the 7 zones. Does those 7 zones also apply to craft growers? Do they also have to be within the 7 zones?
No, we have not put any caps or district requirements for anything other than the dispensaries. The only requirement would be the zoning district that it's located in.
I will add, though, again, because we've had some people asking this question within the department, is because a craft grower can have a certain amount of the area of their craft grower facility used for retail sales, same-site retail sales, that craft grower then would have to go through the lottery process because it's a dispensary at that point. It's a craft grower with same-site dispensary that has to go through the lottery.
Okay, thank you.
Private events, the permitted consumption are okay?
No.
No?
No, the city of Chicago does not allow for any on-site consumption.
To the public?
Open, right, there's a license to the public, that's open to the public.
Right, I'm talking about private events, not public events.
In your private residence, you can only
Privately owned
consume,
buildings.
right, you can only consume in your private residence or private location that you were authorized to do so by the owner.
So the owner must give permission. And I wasn't even speaking of residences, I was going to ask specifically about boats.
You cannot consume cannabis in any motor vehicle, and a boat is considered a motor vehicle.
And is that true for the passengers and the captain?
That's true for anyone on the motor vehicle cannot consume, so. Good try, though, good try. Tell me the name of your boat, so I won't,
As a segue to the question regarding the craft growers, and then if you wanted to do resale, if you sold seedlings, is that considered a dispensary so that you grow your large ones, but maybe you can sell a plant versus an actual ground product? Is that still considered a dispensary?
If it's a retail sale, then counts as a dispensary. If it's a retail sale to the consumer, yes.
Okay.
I had just wanted to make sure, point of clarification. So with the craft grow license, from my understanding is you're not automatically allowed to have a retail component. It simply states that you have the right with a retail license to operate at the same facility.
Correct.
So as a craft grower, I can't open up a store in front of my craft grower and just sell without a
State license.
you would
Without
still
a
need a
state
dispensary license.
And then I
right.
guess my second question is, do you guys have a plan on how to deal with some of the minutia related to the lottery process? In that, as the BLS zone for retail here in Illinois obviously includes Chicago and the surrounding suburbs, with a large portion of the licenses being directed to that zone and a large amount of people applying in Chicago, and the capital requirements and requiring property, the capital expenditures to build out a location, and the revenue expected are dramatically different from each zone. So when you're talking about trying to build a business plan that could be deemed successful in the eyes of an investor or a larger company, it's really difficult to do that without being allowed a little bit more clarification on exactly where you're going to be going. So maybe something like a process for applying within zones, or something else that some of the other larger markets have done, with just a straight lottery, I think, and then the timelines to be able to open from that point can kind of make this a really difficult system in implementation.
Sure. So the lottery, again, is only, although the state is licensing the Chicago region, which is the BLS region, the lottery is only designated in the city of Chicago limits, the city limits, right? And so within the city of Chicago, yes, you may have different rents depending on where you are and what area of the city. but the designation overall in the city will be determined by the lottery process. The 180 days that you have to establish your business once you have the license, if for some reason you're unable to make it through our zoning process, the state will allow you to request an extension of the 180 days.
So community development plan and specific purpose for a business to be within a zone has, I guess, limited inflection in terms of the scoring. It's just who's applying, who wants to leave Chicago, here's the lottery, here's where you go.
Correct.
Great, thank you.
Hi, there was an earlier question about cannabis consumption in private events. There was a question about cannabis consumption in private events, and you said that had to be done in a residence, a private residence.
You cannot consume cannabis in a public place.
Right.
And so outside of your private residence or any place where the public or there's an expectation that you could be seen by others, you're not allowed to consume. And so when you say an event that's held in a public property or public place would not be allowed, you would not be allowed consumption.
And then are dispensaries, licensed dispensaries that were, I guess, either acting as sponsors or attendees of the event allowed to sell cannabis at that private event on a private residence?
Right, so if you're saying that a licensed dispensary was having an event inside of their dispensary?
Or a private residence?
If you're in a private residence, if the owner is allowed you to consume in their private residence, then that's allowable.
Okay, thank you.
Hi. So I know that you can't go and solicit any type of business proposals to a craft grow at the site, but I wanted to ask if it's possible to at least go in and maybe have a tour of the place, or if the craft grow decides to maybe install a sort of system to have guests come in and check out the facility for a set price. Would that be at all possible?
To visit the facility?
Yeah, the tour, and then also I'm sure that it would also facilitate that visitation from any state officials or maybe local officials that want to make sure that everything's up to code.
So any state licensed cannabis business enterprise would have to have permission by the state to allow anyone who's not licensed or badged to work in that facility to come inside of the facility. So it's up to the individual owner, but they would have to submit the names of the individuals to the state, and the state would have to authorize that.
Okay, and would the authorization happen on a very expedited basis, or would it be long-term as well?
I can't speak to that. It's a state issue, so we'd have to have the state answer that for you.
Well, I would advocate for that to happen soon, and I just want to go out with Illinois guys. Check it out. Check it out. Sushi.design.
Yeah, so if I was to be in, if I was to apply for the zoning amendment, and I'm in the process of doing the zoning amendment, and you guys receive the application from the state, and I'm going through the process of doing the zoning amendment, what do you guys see happening from that particular point?
If you're still going through the process, we cannot sign off on any of those boxes. We could sign off on the one that says you're not allowed, because you're not until that passes through city council and the zoning is in place. And then at that point, we can say that you could enter into the special use application, but we can't sign off on anything because we're not certain that the zoning is going to change.
But would you hold on to the application until the final?
You shouldn't bring the application in until you have the zoning in place,
Well-
because first of all, you're going to have to apply for the opinion letter. And again, if you're zoned C1 and you apply for the opinion letter, we're going to say it is not allowed, and that's it. And that'll be the end of the process.
So does the state application come via us, via the applicant, or via the state?
No, the applicant.
All right, excuse me. I was late because I couldn't be in two places at one time. But downstairs, I think they said that they're not going to have any peddler license for cannabis, are they?
That is correct.
All right. And another thing, I didn't miss out on the zoning, but how do you qualify where the zoning is gonna be? I mean, what is it that you use to measure on zoning can be here or zoning can be there? You know, how do we know? What is it that makes you say this is a zoning spot for a cannabis place?
Well, I mean, the city is mapped out with
Right.
all of the districts that allow for this type of use currently, from the northwest side to the southeast side.
Okay.
So the districts are in place today.
Uh-huh.
As far as what is the appropriate zoning, if you need a zoning change, like the one gentleman's asking about, there is a set of criteria set forth in the Chicago Municipal Code, in the zoning ordinance, that have to be met for a zoning change, or at least to get the recommendation of the city.
Okay.
So it's all laid out.
All right, I'll look that up, but can you give me like an example? Like, you know, like a pedophile can't live in the area where children are in a certain distance. What is it that you use? Give me just a little example as to how do you decide where a zoning area would be. So you may see a building that this would be a nice place to have a depository,
That
and
building
then
then is already zoned, ma'am.
what did you say?
That building already has certain zoning on it. So let's say that building, you see a building right next door to yours.
Right.
You could enter that address into the City of Chicago zoning website, and it would tell you what that property is zoned.
All
Right?
right.
So if it's zoned C2, let's say, then you've made sort of the first step to acknowledging that then you could pursue a special use for the cannabis business establishment there, so long as that property isn't within 500 feet of a school.
All right, so I guess I'm going to have to look up what's the difference in C2, C1, C3.
Right,
and-
so that's where you would start, because the property's already zoned.
All right, so dispensaries can't be in every zone?
Correct.
So that's what I need to know. What zones do they discriminate against?
So if you go to the city's website,
I mean, but I'm wondering, why do you discriminate against this zone? Why
Well,
can't
city
all
council-
zones have a
because
dispensary? Like
each-
all zones have stores?
Each zoning district goes from a less permissive to more permissive in uses. So if it's a B1 district, it's less permissive than a B3 district. Commercial districts are more permissive than business districts. Then the commercial districts go from a C1 to a C3. Again, the C1 less permissive, the C3 is the most permissive.
Oh.
So because we're treating this use similarly as we do to liquor. So we're allowing it in or city council decided to allow it in the most permissive zoning districts.
Okay, it's similar to liquor, but if you had a party, liquor is allowed to be sold in the place where you said that you can't sell cannabis in a
I said
public-
similar, not identical.
I know, I'm saying, so it's tricky with words. All right.
so we're running short on time, so we have time for two more questions.
Let's do one more question and
And
then
then,
one more
but
question.
we're not leaving, so we're just gonna break the panel, and then if anyone has any questions, feel free to come up and speak to us. Okay.
Hello, guys. Hey, I was just wondering, with obtaining your license, the 90-day extension you guys got on it, is it no way that you can just obtain these licenses without this 90-day obligation? I mean, just saying for, like, just to be prepared, or you want to look into the future of going into this, ain't no way you can just, like, have your license and then figure out your plan and then go into it whenever? Is it only the 90-day obligation?
So two different things. So you get the state license, and we're talking about dispensaries, and it's a different process for craft growers. But if you're talking about a dispensary, you get the state license for the dispensary, and then you come in to us for the special use. So when you say the 90 days Steve referenced earlier, that's for the special use for a dispensary. You'll already have your state license by then, and then you come to us to get the special use to be able to open your location in the city. The other way for a craft grower, you would need to have your location identified and apply for a special use, but you don't have to move through that 90-day special use process before you apply to the state for your license.
Also, you're saying that these different applications, correct?
They are different applications.
Thank you.
So I thought the lottery was just for the initial bulk of dispensaries.
but it sounds like you're holding on to it. So I just want to know how I can oppose it and or change that, because the lottery system is not working. So who do I go to? Is that the state? Is that the mayor's office? Who is that?
That'd be me. So,
Beware what you say.
and let me tell you, so zoning is really tied to land use, but we also see this as a social equity opportunity because we wanted to make certain that these dispensaries were located throughout the city.
And they're not right now.
Right, exactly. So the only way to do that is to make certain that you put a cap on how many can go in any particular area of the city, so that if you want to be in Chicago, you have to go wherever there's an available district for you to site in. So that's why we determined that we needed to put together the district and the caps so that all areas of the city would have access to these businesses. We haven't set the next lottery
Sorry,
date
so you
yet.
didn't really answer my question. What office do I or other citizens?
My
or
name
other
is Paul
community
Stewart,
organizations-
and
What
I'm
is that?
Paul Stewart, and I'm in the mayor's office. Yeah, sure.
Yeah, I got one question. Roughly, how much money does it take to get in the business to be able to sell marijuana?
That's a loaded
Give me
question.
a dollar figure. That's the fact. Because let me tell you something. You got a whole lot of people been in this business for 100 years, and they have been cut out of it. You got people here have been big shots, hyperlooting, and they're going to make the money. You see what I'm trying to say? The lady asked y'all about a peddler license. You gave it no consideration. Why didn't you give it no consideration? These people need to make a living too. So when y'all scrap at the bill, why didn't you figure so that people at the bottom will be able to get into the game and get to the middle?
Sure. So let me address that. Number one, the state of Illinois is the licensing authority.
Let
me address your question.
Hold it, brother. I'm talking about the politicians.
Right.
That's a bunch of crooks.
Right, they're not here.
But you represent. See, I'm telling you, tell them. This, like the lady just said, this thing is so unfair, it's pathetic.
Understood.
In the ghetto, there's nobody making a dime. They're just giving their money away to some rich, polluting, nonsense criminals. That's who will make all the money. That's not fair, man.
Thank you. Thank you all for being here.
All right,
We
thank you all.
appreciate it. Thank you.